able to provide the wake, mass, and entombment with a beloved husband in her crypt. But this was after her remaining 3 weeks in the hospital morgue while the distant relatives were contacted and papers were signed. So that just brings out the importance of having that agent form if your relatives are not in this country. All our funeral directors at Gleason Funeral Home have years of experience and training and are available 7 days a week. Also, there is no charge to make pre-arrangements. Honorably discharged veterans are entitled to a grave for themselves and spouse at a national veteran cemetery. It is very important to have a copy of your honorable discharge. Also, we will arrange to have military honors for the veteran. And for a death out of town, we suggest always to pull Gleason's first. Then we'll contact somebody, whether it's Florida or California, to ship the deceased back to New York. If anybody has any questions, feel free to ask me or any one of our directors that are here. And, does anybody have any questions? Yes, please. I would definitely recommend an agent form, even if you have an executor, because, if there's a closer blood relative, they're actually supersede the executor. And yes, I mean. Is your question if you want to make pre-arrangements, can you do it in Whitestone? Yes, you can. Yes, and any one of the Gleason, Flushing, Bayside, or Whitestone. You can pick out whatever exactly what you want. We have selection rooms in all 3 funeral homes. Yes, sir.
What is the average cost?
Well, a ballpark between 10 and 15,000, including the cemetery and some other fees. Yes, sir.
Whatever you want, you can do it up front. They can pay for it. They go into the bank and put it into it. And you say, doctor, now, once I know, in 2 years, what would be the payment? Would be the agreed upon payment or whatever is in the bank? We collect all the bank.
Well, the price would be the price at the time of death, including what they charge to open the grave at the time. And unfortunately, the prices do go up every year, but the interest helps accumulate and help pay for the sum of the increases.
My question is, once the person dies, is the bank account in that, or they stay out? Or do we determine agreed upon price used or what?
Well, all the money in the account is used to pay for your funeral expenses at the time of death. And if there's an overage, money will be refunded as long as it's not Medicaid. If there's a shortage, then the family would have to pay the difference.
The arranged total price goes up every year.
Yes, the cemetery goes up. Unfortunately, inflation goes up, and that's. But at least you can also adjust if you pick a $2,000 casket and you find you're short and want to pick a $1,500 casket and not pay anything. You can do that too. It's flexible.
Thank you.
You're welcome. Okay, at this time, I would like to introduce Ann-Margaret Carrozza, a nationwide. I'm sorry.
Yeah, no, I'm sorry. What's the advantage of prepaying that if cemetery wants like that? And
Well, one advantage, if you're going in a nursing home, rather than have all the money go to the nursing home, you can fund your funeral, and it's exempt from the nursing home. And, you know, if you have round the clock care at home, it's exempt from the government, and that's the big advantage.
You're not paying the price now for the funeral, and that price will be reflected, you know, years from now, in other words, the price of the funeral goes up. What you paid will not have to pay more.
It's possible you have to pay more, yes. I mean, we have no control of what's gonna happen in the future. And, but at least the majority of it is paid and your wishes are on file, and, you know, your next of kin doesn't have to go running around making decisions at a difficult time. Okay. Oh, thanks. So at this time, I would like to introduce Ann-Margaret Carrozza, a nationwide respected expert elder care estate planning attorney. We are fortunate to have her here today.
Good morning, everyone. And we're here together on this rainy day to talk about funeral planning and wills. I think all of our friends will be jealous on Monday when we tell them what we did this weekend. It's very, very important to talk about these things. I think I view today as an information exchange. And they say that the fear of aging is our number 2 fear as human beings. And I think part of that is worrying about what our, last days are going to look like. But we have tools that we can use today to shape what our future looks like. So what can the me of today do for the care and feeding of the me 20 years from now, right? So especially women have an 80% chance of being the surviving spouse. And in modern reality, can we rely on children to care for us? No, we can't rely on children to care for us. Through no fault of their own, they have sometimes 2 jobs and kids, and it's simply unworkable. Generations ago, that's how it was. Many of us here in this room have experienced taking care of an elderly loved one. And we should be very proud that we did that, but that's not always the modern reality. So we need to inform ourselves about what we can do to ensure that our future years are terrific and wonderful. And I think when we inform ourselves, we feel a little bit less frightened about something. So with that in mind, let's jump right in to the topic of estate planning and asset protection. When we talk about estate planning, what is this blocking the view for Zoom, the podium? No,
That's what you look like.
when we talk about estate planning, what is the number 1 document that people think of? A will. And not to put you on the spot, but can I ask by a show of hands, who has a will? Okay, most of us in the room have a will. And a will is very, very important because it determines who gets my stuff many years from now. But what a will alone does not do is avoid probate for the family, protect our assets from taxes, and of great importance today is protecting assets from long-term care liabilities. So the topic of long-term care planning has never been more important because we're living longer. You know, that's a reality. I'm practicing over 20 years, and the ages of the folks who come into my office in Bayside today are, 15 and 20 years older than when I was first practicing. I had an 86-year-old woman come in a couple of weeks ago, and 86 is nothing today, but she said something about her mother. So the mother lives with her, and I said to her, with your genes, you need to be saving your money because you need it to last a very long time. So we're living longer, and the cost of long-term care is literally going through the roof. It is crazy, and people think that I have Medicare, I have a Medicare supplement, maybe I have some long-term care insurance. And I would say in 100% of those cases, we're not properly covered for long-term care. So let's jump in to long-term care planning. None of us wake up and say, I want to go to a nursing home today. Something bad happens and we go to the hospital. It could be a broken hip, a cardiac event. We go to the hospital where Medicare and the Medicare supplement usually cover everything beautifully. When we leave the hospital, where do we go today? We go to rehab. Years ago, we'd stay in the hospital until we were well enough to come home. That is not the case now because hospitals get paid based on my diagnosis, not based on how many days I was taking up space in a hospital bed. So it behooves them, they say, to get us out quicker and sicker and we're in no shape to go home. So we go to rehab. At the rehab level of care, Medicare and the supplement only cover up to, does anyone know? 100 days. Okay, so during that 100 days, we need to make sure that our assets are beautifully protected. So we think in terms of 3 categories of assets. The first category, retirement accounts, whether that's a 403B, a 401k, an IRA, a TDA. Do we have any retired teachers in the room? Okay, your big, beautiful TDAs, 457, whatever the retirement account is, that is already invisible to long-term care. A lot of people don't know that. So you came into this room with those assets already protected. And we will typically have our spouse as the primary beneficiary. We will name the children as the backup beneficiaries. Do I need to change the beneficiaries if someone dies? Well, it depends on how it was originally set up. If I name my husband as the primary beneficiary and he dies, and I have backup beneficiaries, then I don't have to do anything. But what comes as a surprise to people is I should change him as the beneficiary if he's alive, but with a long-term illness. If he has a dementia-related illness, Parkinson's, whatever his possible long-term illness is, he should no longer be the direct beneficiary on my retirement account. Because if I unexpectedly die first and everything is paid into his lap, the nursing home will grab everything. So just remember, if there is a change in circumstance, we need to revisit the planning. Okay, so retirement accounts are good to go. Our next asset class that we want to think about is real estate. Does anyone here own a home? Okay, do we have any co-ops? Any condos? Okay, so condos and homes are in the same category. What do we want to do with the real estate in order to render it invisible to nursing home or home care claims? A trust. We want to do a trust. And you know, a lot of people ask, do I need a trust or no? And the answer, I think, is what kind of trust do I need? Because without a trust, it's the real estate, it's the house, it's the condo, it's the co-op that pushes the family into probate. So we should all have a nice will. And I think the overwhelming majority of us here have a will in place, but the goal is not to have to use it because that will would go to probate. And New York state law says that a probate must be open for a minimum of 7 months. That means that one of the kids has to cough up the money for the co-op maintenance, has to ensure that property taxes and property insurance are paid. And you know what happens to property insurance when the individual dies and it's an empty house? That property insurance goes through the roof. It's a nightmare. So 7 months, the probate must be open for. Again, I'm practicing for over 20 years. I've never seen a probate wind up that quickly. All right, you're looking at a year for a probate. So we want to avoid that, and we avoid that with a trust. Should the trust be revocable or irrevocable to protect the house? Ideally, it's somewhere in the middle, right? So a revocable trust is very appealing psychologically, right? You can buy it on QVC. Susie Orman sells the kits. You can put your assets in. You can take your assets out. You're your own trustee. So it's very appealing. But the question is, if I am my own trustee with a revocable trust, and I can put the stuff in and I can take the stuff out, does that protect anything from my nursing home? No, it's common sense. If I can get my hot little hands on the asset, then so can my nursing home. So, you know, many of my colleagues out there do these revocable trust seminars. I get the cards in the mail to go to these revocable trust seminars. And if your goal is to go there and meet some new friends and have refreshments, then it's a good idea. Some people go to these things with a Ziploc bag, which it reminds me of my dearly departed grandmother, and she blamed it on the Depression, but she would bring a Ziploc. Does anyone remember Beefsteak Charlie's? The shrimp. Well, there were no shrimp left after she got to the buffet. They were all in the Ziploc in her pocketbook. So don't be jealous of the highbrow family that I come from. But she was so dismayed when they went out of business. And then I told her it was her fault. So the revocable trust is like water. It doesn't protect anything. Now, on the other side of the continuum is a totally irrevocable trust. You never need a totally irrevocable trust. And there are very few absolutes in this area of the law, but I'll go as far as to say you never need a totally irrevocable trust. A totally irrevocable trust ties my hands. and I can't make a change if, God forbid, a child or another beneficiary predeceases me. Do I want my son's 1/3 share going to, under his will, where does his interest go? To his wife. I definitely don't want that. So a good trust will enable the grantor or the settlor, that's the person who sets it up. A good trust will allow me to make changes between and amongst my named beneficiaries, my lineal descendants, and trusts for their benefit. So let's say I have my 3 kids as the initial beneficiaries, and 10 years after I do the trust, one of my beneficiaries is diagnosed with a psychiatric issue, with their own disability, their own long-term care. Now I want that beneficiary's interest to be held in a continuing trust for their future benefit. So we want to have the ability to put our hands back in here and make some changes. Does anyone have any questions so far on the trust? Yes. Okay, so the question is, what is this? I think of it as a hybrid trust because it has elements of being revocable. I can change my beneficiaries. I can change my trustee if the trust is drafted properly. I can specify in the trust that no one can sell the contents of the trust, which is my home, without my legal agreement, my written signature. So I'm not giving up any power within this. There is one difference. What is the difference then? If I can make all of these changes, how is it protecting the asset in it? Well, if I have John as my trustee and the trust owns my home, I want to draft the trust so that he can't sell it out from under me. But here's the one difference. If I want to sell the home, we need my signature plus my trustee's signature. That one little fly in the ointment we put there purposefully to get this magical 5-year clock ticking. So if I need my trustee's signature to sell, and we have the 5 years go by, and then I'm in Ozanam nursing home one day, they can't get at the house because Ann-Margaret Carrozza, acting alone, can't sell it. My partner and I together, however, can do whatever needs to be done. Now, playing devil's advocate, if my trustee moves or has his own issues or doesn't think it's a good idea for me to sell, I retain the ability to remove him as the trustee, and my friend Dave Lagaz will now be my new trustee because he's going to agree to whatever I want to do. So in a properly drafted hybrid trust, the trustee is really only a placeholder that I appoint and they serve at my will. So back to what is this magical trust called? Whatever we call it is irrelevant. What matters is like the rules of a board game, right? The specific provisions in every page of this trust added together establish our rights and responsibilities with respect to the asset in it. Yeah.
If the person that has the trust develops dementia or Alzheimer's, and if the situation is set up where the house can't be sold without that person's signature, can the person with the power of attorney then sign for that person?
Yes, Marilyn. So sometimes I want to, for checks and balances, if we're lucky enough to have a lot of players in our lives, I pick one trusted person as my trustee. I can pick another person as my power of attorney, and that is the person who can sign for me in the event that I'm legally or physically incapacitated. Yes, sir.
Why ever do an irrevocable?
Okay, why ever do an irrevocable? So here's my plug for my book, Love and Money, which is now deeply discounted on Amazon. I tell the story, and some of you have heard it before, of an attorney in the Northeast Queens area, and I give him a different name in the book. He does personal injury law, and he called me one day that he was doing a trust. Would I look at it for him? And I took it home. I didn't know why he was doing a trust, and it was really a disaster. It was like the legal equivalent of a horror movie. He's referring to provisions of the Internal Revenue Code that were repealed decades earlier. And I got the sense that he got this template from some retired or deceased attorney and cut and pasted the names. And now I'm in this Dear Abby quandary. I didn't know what to tell him. So on Monday, I said, I need some more information about your client to really review the trust. Now, should he have given me any information about his client? Oh, no. He asked for my fax number, and now I have the Charles Schwab account, social security numbers. I cobbled together a much better trust. And now this is a male-female dynamic, maybe. I still don't want to really hurt his feelings. So I said, I made some changes. Now, there was not one semicolon remaining from what he gave me. I made some changes. And you know what he said? Well, good to know I was generally on the right track. So now the scary part is this guy to this day has a shingle out that says he does elder law, because he has this one out of maybe 25 different trusts that I might do for someone. He has one, and he peddles that, and I think it's like a broken clock. You know, it's right twice a day. Maybe you get lucky and it's right. So, you know, why ever do a totally irrevocable trust? I think maybe because the attorney doesn't quite know where they need to stop on this spectrum between revocable and totally irrevocable. So think of a fulcrum and a seesaw. The idea is for it to be as flexible as possible without it tipping into being in the revocable camp. And we come down to that perfect nuance by me acting alone. I cannot sell the property, but I put my trusted yes man in there, and the two of us together can sell the property to a third party. Yes.
If your co-trustee predeceases you, how much time do you have before that trust becomes invalid?
So a trust would not necessarily. Oh, yeah, good. Thank you.
Is a revocable trust.
Okay, so what happens when a trustee predeceases, or has a long-term illness, or quits his or her post? What is the time constant involved? You don't necessarily have a breakneck rush to replace this person. Typically, within the trust, we say John is my primary trustee, Dave is my backup trustee. So someone pops up automatically. And then there's a paragraph that says, notwithstanding my appointment of John and Dave, I retain the right for any reason or no reason to remove and replace my trustee. So that's an election that I would have to make before something needs to be done. So if there's a closing coming up, I need to have a valid trustee in there.
Can you do it without the trustees? Like if you have a home, you have 2 children, and you decide you want to sell it, but you don't want to have to involve your children, can you do it?
So if you have an asset protection trust that owns the property, you need a trustee in order to sell the property.
So you still have to get your children's permission.
It doesn't have to, no, it's not permission. It's a rubber stamp. Because if they don't, or if you don't want to involve them in your personal issues, have a colleague do it. Have your brother-in-law as the trustee. Have your CPA, your financial advisor, your clergy member as your trustee. So you know the dynamics in your family, and maybe I don't want my son to be the trustee because I know his wife is going to be, telling him what to do and what not to do. So I want to go to my financial advisor, Josh, who's here today, and he's going to be a nice guy and do whatever I want to have done. Yes, sir.
Sorry to follow up. Is it a non-revocative and strong thing to take it out of the state and say how
Can you repeat the question?
was the non-revocative stronger, greater assurance to take it out of the estate than the hybrid trust?
Okay, so the hybrid trust is not designed to remove something from your gross taxable estate. We don't want to pull the house out of our gross taxable estate for estate tax purposes. In New York, we have a $6.9 million estate tax threshold. On the federal level, we have currently a $12.9 million transfer tax threshold. If you're saying to yourself, well, I'm way below that, I never have to think about that again, what goes up can come back down. And I can tell you that my former colleagues in Albany are talking about bringing the New York State threshold back down. But we would always want the house to be includable in the gross taxable estate. Why? Because that's how our beneficiaries get rid of the capital gains, right? Only assets that are includable in my gross taxable estate, but again, they're not taxable if it's under 6.9 million. For having this tax-free trip through my gross taxable estate, the kids or other beneficiaries will take the highly appreciated house that you bought for $50,000 and it's now worth $1 million, 2 blocks from here. All of that capital gain gets eliminated if we did not either gift the house to the kids. If you remember nothing from this morning, it is never, ever a good idea to gift real estate to your beneficiaries. If I bought the real estate for $50,000 and it's now worth $1 million, and I give it to my son and daughter, they will take my original cost as their basis to measure gain later. And even if they're nice kids and they let mama live there for the rest of my life, what's going to happen to my star property tax exemption? Gone. What happens if one of my kids is in a divorce? Now their soon-to-be ex has an interest in that real estate. And when my beloved grandchildren apply for college financial aid, their parents' ownership interest in grandma's house will count against them. You know, never, ever, ever think about gifting the property to the kids. And again, I would not put the primary residence or anything else below 6.9 million. I would not put that into an estate tax type of trust. It's only when we have assets that are greater than 12.9 million today, would we do this estate tax trust to clip the hedges, so to speak, and put the overage into that trust to get it out of the gross taxable estate. For anyone who has assets below 6.9 million, you don't need to think about the estate tax. However, and I'm not going to put you on the spot by asking for a show of hands, if we're a little bit over the 6.9 million, then we need to do some planning. If as a couple, we have 7.9 million, you would think, I'm a person, I have a $6.9 million credit. My husband is a person, he has a $6.9 million credit. But the tax system is designed for us to lose the first credit. So with a simple mom and pop will, upon my death, husband gets everything. There's never a tax on that first death because of the unlimited marital deduction. I could give 50 million to my spouse and there's no tax. But because there was no tax liability, there was no opportunity for me to use my little Macy's gift card, that first credit, it expires. And now my surviving spouse with 7.9 million dies and wants to leave everything to the kids. They can only use his single $6.9 million credit, leaving 1 million on the table for Albany to take a third of. So if we're poking up a little bit above that threshold, we need to take some action. And on the federal level, the 12.9 is scheduled by its own terms to come crashing back down to a little over 5 million at the end of 2025. So anyone with an estate tax concern, you need to do a little bit of special planning. All right, any other questions? Yes.
If a trustee is starting to have memory problems that they don't acknowledge, are you able to remove them as a trustee without them knowing about it? Because it might upset them.
Oh, what an excellent question. We already said that with a properly drafted trust, you can remove and replace your trustee for any reason or no reason. Do we have to tell them? No, we don't have to tell them. We would simply revise the trust with the attorney and prepare an acceptance for the new trustee to execute. Yes.
I think you mentioned earlier something about 5 years. Do the trusts have to be in place for 5 years before they're valid?
Okay, so what exactly do we mean when we say this magical 5-year period? That is federal law that says the asset must be in this trust for 5 years before it's rendered invisible in order to allow me to apply for Medicaid or another government program. That period of time, think of it as a cooling off period or a baking period. It used to be 3 years. And then in 2006, it went to 5 years. There are 2 bills today in Congress, one that would make it 10 years and one that would make it 7 years. So, you know, for the younger folks in the room, the writing is on the wall. This program is not going to be there in its current form in 20 years. The government can't afford it. On the New York State level, Medicaid has taken over education as a percentage of the New York State budget. So they're making it more and more difficult. But I do want to give you a few thoughts about the Medicaid program, because there's a lot of misinformation out there. And some of you know, my misspent youth was in the New York State legislature for 14 years. And in fact, some of you not only know about it, some of you here today helped me get there way back when in 1996. I'm looking at Mr. and Mrs. Salamone in the back. I would not have won that first election without you guys. But in the legislature, we talked a lot about the Medicaid program, and a lot of opponents, you know, of course, it's a politically charged issue, and folks, without becoming partisan, some folks said we need to cut that program, you know, we can't let people protect their assets and get onto the program. That California and Texas combined has a lower Medicaid budget than New York State. But do you know why that's true? Because no one has such a good Medicaid program as New York State. It is, if you think that if your spouse or your parent needs to go onto Medicaid, that it's a third world type of coverage, it's not in New York. It is illegal within a given skilled nursing facility for them to differentiate between me because I'm on Medicaid and you're privately paying the $16,000 a month. Everything is even Steven. And some of you know I'm married to a geriatric physician, and on one of our first dates, I asked him, is there any little, note in the chart that so-and-so is on Medicaid? Cynic that I am, and no, it's 100% equal. So you can have crummy facilities and better facilities, but within a given facility, the care is 100% equal. Does Medicaid pay Osnum or the Grand $16,000 a month for me? No, but they don't pay much below $10,000 a month. So the facility is very happy to have Medicaid folks in there. And as it relates to home care, if you're afraid that they're going to send Frankenstein to the house to take care of me, you're allowed to hire your own person, right? You see these commercials, your granddaughter can get paid for providing care. So it's a super wonderful program that's out there. Will it be there in even 15 years? I don't think so. All right, any other questions on the trust? Do we have any Zoom?
We do.
Okay.
One question is, does a trustee get paid for being the trustee after someone passes?
Does the trustee get paid? And I would say that the practical answer is in a nice, harmonious situation, and there are a handful of those out there. In a nice, harmonious situation, the named trustee will not accept the commission because they would be getting 1/3 of that anyway, right? Number one. Number two, the commission is income taxable to them. So they just leave it in the pot and receive 1/3 of what's left without any taxes. However, just yesterday, I had someone in the office saying, I'm going to take the commission. And I said, it's subject to income tax. And they said, my brother deserves it. He's been a real SOB. So the taking of commissions is often to settle a score.
Okay, we do have 3 more.
Yes.
If you have time. Okay, the next one is, can you create a trust for people who live in Florida or Maryland?
Okay, can a practitioner in one state create a trust for someone who lives in Florida or Maryland? And the same way that you can buy, forms off of the internet, which I don't recommend, an attorney can create documents for residents of any state, but they need to be signed in the state where that attorney is licensed. Yeah, so we often have folks with New York property and property in another state, and we can put all of that into the same trust.
Thank you. Next, if my son is my trustee and he gets married and then divorced, can the wife get ownership of my assets such as bank accounts, IRA, and real estate?
Okay, so let's talk a little more generally about divorce and spousal interests in all of this. I very much like to try and protect inheritances from future possible divorces or other breakups. Is an inherited asset subject to distribution in a divorce? If we're on a game show, the answer would be that an inherited or gifted asset is not subject to equitable distribution in a divorce. But in real life, the judge finds a way to get at that asset. So it's important within the document, within the trust, when I say that Mary, Susie, and Johnny are the beneficiaries, I like to say, as their separate property, not to be commingled with a spouse or partner for the ultimate benefit of my lineal descendants. So now my son doesn't have to have a backbone, he just shows his wife this language. So we customize that language. If my kids are in really bad marital or domestic situations, I might even make stronger language. I might say to Mary, Susie, and Johnny, on the condition that they take legal steps, i.e. a prenup or a postnup, to keep inherited assets separate for the ultimate benefit of my lineal descendants. Now, those of us in or embarking upon a second marriage or a third marriage really need to think about doing a prenup because the divorce rate for second and subsequent marriages is over 60%. And we're dealing with a time in life where I don't have all the years in the world to make up for being financially devastated. Now, I'll go as far as to say that even happily married couples should consider doing a post-nuptial agreement. Why is that? Because I've seen a surviving spouse. So the husband and wife came to me 10 years ago to do the wills, do the trust. One of them passes away, and the surviving spouse, especially if it's a guy, gets remarried. Okay? And what is this new wife angling for from day one? She's, I think, you know, given my peculiar profession, I think if I die first, my husband will be remarried within 6 months. He needs like a personal manager to help him out. And I'm already trying to foil her from getting any of the assets that I want to go to the kids. So now let's go back to the trust language that I gave you. Remember I said we can change the beneficiaries? I gave you some important language. I said we can change the beneficiaries between and amongst the named beneficiaries, our common lineal descendants, not a Tony Randall having some new baby, they're not included, our common lineal descendants, and trusts for their benefit. So the new person that my husband might take up with does not fit that definition. And even if he has a little dementia, which 40% of us are going to have a little bit of an impairment, even if he has a little dementia, and even if she works her wiles on him, he is legally unable to give her part of the house. Does that make any sense? Yeah. Okay, any questions up until this point? Yeah.
Also, the period for this year, will be changed. When did exactly we want that?
Okay, so the 5-year look back period, that's only for a level of care that none of us in the room want, and that's nursing home level care. The overwhelming majority of us who will need some help with activities of daily living, right? The non-glamorous functions of feeding, bathing, dressing, toileting, that can be provided at home. There's nothing medically complex about that level of care. And within a living will, which is a document, you do not need an attorney to do a living will. Within a living will, I have the template on my website. It says, in the event that I require care, I wish for the care to be provided in my home unless it's not medically practicable. The look back period of 5 years is nursing home. Look back period for home care. We currently have no look back period for home care, meaning I can create the trust, throw my stuff in the trust. Again, we don't have to put the retirement accounts in there because they're already invisible. And then I can apply for community Medicaid on November 1st, if I do all of that this coming week. The party there is coming to an end, though, with a 0 look back period for home care. And in 2024, they're talking about April, but this date has been pushed back maybe 10 times already, but it's a matter of when, not if. New York State, for the first time ever, is going to have a look back period for community Medicaid. It's going to jump to 30 months, which is 2.5 years. So, yes.
What are the visible and invisible assets in your nursing home Medicaid versus community Medicaid?
Okay, what are the countable assets for nursing home Medicaid and home care Medicaid? It's an identical asset snapshot. So the financial eligibility criteria is that we must have less than $30,000 in countable assets. And that would not include the $900,000 TDA, that is invisible. So we want to be below that threshold. If a husband and wife do the trust and the house is in the trust and they left the bank accounts in their own names, which is what I encourage people to do, and that husband gets sick, now the wife is going to go to the bank with the power of attorney to close CDs early. You don't care about losing a few dollars of interest, in this situation, and move the assets to the well spouse. There is no 5-year or 2.5-year look back on asset transfers between spouses. So that's an 11th hour planning tool. Yes, sir.
What if there's only one of you?
If there's only one of us, then we do the residence, we do the apartment, the condo, or the house into the trust. And then if we get sick, whoever is our power of attorney will work with the bank in transferring assets into the trust. And we would privately pay for our home care for 2.5 years. And then we can get on to Medicaid. Yes.
When you say that some accounts are invisible, do you have to be collecting income on them, or they can just sit there?
That's an excellent question. When I said that retirement accounts are invisible, they must be in payout status for them to be counted as invisible. And you know that once we're 72, they must be in payout status because that's when we start pulling the required minimum distributions. If we're younger than 72, then we would simply put them into payout status early in order for them to be invisible. Yes.
If we do
If we do a trust, does that affect the STAR program? I did not ask you to ask that question, but it makes me feel a little bit better about my 14-year stint in the legislature. That was my bill in 1998 that Governor Pataki signed. And prior to that, even if you did a revocable trust, you lost your star tax exemption. So this bill said, if your trust gives you 100% of the use, the occupancy, the ownership rights, then you keep your star, you keep your enhanced star, the spouse's veterans exemption, everything remains. Yes. There's a phone going. Can you repeat that? Yeah, so if you want to customize your distribution, you should do that. If you want to leave the example you gave, you want to leave the house to someone and the contents of the house to someone else, yes, you can do that. You just want to be very clear. You know, people fight when things are unclear, and sometimes, you know, a parent doesn't want to make waves and they don't bring up difficult topics during life, but we have to. If I loan my daughter $100,000 as a down payment, and then years go by, she had some bad luck, she got divorced and married and divorced again, and she's struggling financially. And I kind of just informally stopped asking her, you know, to repay it. At my death, there's going to be a lot of upset feelings about that, because her brothers are going to say, hey, your share needs to be docked by $100,000 because mom only loaned that to you. And then she's going to say to them, well, you know, when I was driving her to chemo and you were too busy, she told me to forget about it. Well, that case ends up in court. So, you know, maybe we want to say in the will that if we want the sides balanced at death, and I loaned my daughter $100,000, how do we balance up the sides? This is the #1 mistake I see out there, and attorneys make this mistake. Attorneys say, Susie gets $100,000 less. Should that be the result? No, that is a wrong result, because if Susie repaid that $100,000, she'd be getting 33 of it upon my death, right? Imagine that there were no other assets. It's easy to understand. If she had paid that back and my estate is $100,000, each of them gets 1/3 of that. So I should never say that her share is docked for the amount that was borrowed. Instead, I should say that Charlie and Fred get $100,000 off the top, and now they're all equal, and then they go on to split equally anything that may be left. So we really, you know, part of this process, we want to take a step back and think about the things that could cause conflict and confusion later. Yes.
In a revocable trust, can the trustee and the power of attorney be the same person?
So can a trustee, whether it's revocable, irrevocable, or hybrid, and a power of attorney agent be the same person? And the answer is yes. So not many of us are fortunate enough to have someone who is logical with a good head on their shoulders, and we typically go to the same person for all of those appointment agents. Do we have any Zoom?
Yes, we have a bunch. The first one is, should I get a trust at the age of 61 if I'm still working?
Okay, at what age should we get a trust? There's no magic age. I have a trust, I'm not 61, with the example. I think we want to think not only in terms of, this long-term care planning, we want to think in terms of liability protection. You can't turn the TV on today without, a law firm. Trip and fall, did someone look at you the wrong way? You may have a lawsuit. And any of us with real estate need to think in terms of protecting that asset from slip and fall actions, from garden variety liability. The mailman breaks his head on my front stoop. If you have liability protection, which can be the form of a hybrid trust, then I think we're all better off. Now, this is a good point to very quickly highlight the differences between a trust. You've heard of an LLC, an LLP, an S Corp. What those things all have in common is they protect the asset from garden variety liability. However, I never want my primary residence to be owned by anything other than a trust, because we would lose the property tax exemption. So an LLC, if any of you have, a 6-family in Jackson Heights that you rent out and you put it in an LLC, that's great for liability protection. It doesn't get us all the way home though, because that LLC would still have to go to probate and it would still be reachable by a nursing home. So you keep the deed in the name of the LLC, but let's take that LLC book and transfer the membership units into this hybrid trust. Now you're avoiding probate, you have the liability protection, and it's invisible from a nursing home 5 years down the road. Yes.
Maybe that's something to understand, but if you have long-term care insurance, but when you're going to give me Medicaid, you have to use the long-term care first before you can be out of the community medical.
So
insurance companies who agree to let you use the money.
yeah, so let's talk a tiny bit about long-term care insurance generally. Does anyone here have long-term care insurance? Okay, so you're head and shoulders above most people. But what you want to have in the back of your mind is, can they raise your premiums in time to come? Yes. So it's not a fair playing field in a certain respect, because I could be paying my annual premiums nicely for 15 years, and then at my 80th birthday, they drastically raise the premium. I would never say, don't have this insurance, because again, the Medicaid program will not be there, in my opinion, 15, 20 years from now. But the long-term care insurance that you may already have is a piece of the overall planning. So if I have a long-term care policy with a benefit of $300 a day, I still have an exposure at Ozanam or the Grand of $250 a day, because the daily rate is $550. And even though the policy may have, some eye-popping $1 million lifetime benefit, if they're only letting me use it at the rate of $300 a day, you're in my office applying for Medicaid anyway for the difference. So for those of you who don't have long-term care insurance, the only thing that I would tell you to think about is, they call it a hybrid long-term care policy. And not to put you on the spot, Josh Frankel, but I mean, anyone who's interested can ask him about it. It is a life insurance product that has a rider for long-term care use. And if I die in my sleep one day, which I hope will be the case, my beneficiaries get the death benefit. So it's terrific, whereas the traditional long-term care policy If I don't use the benefits, then there's nothing at my death, and I, threw the money out the window all of these years. Yes, sir.
And so a quick question, to go back to the personal insurance liability. If we have a home, say we have $1 million liability policy, a policy for, in case someone were to sue us. I forget the name of that policy.
Umbrella?
Umbrella policy, thank you. And the person who sues and is up and above that amount, and I don't have a trust for my home, they can come after my home for that, right?
Well, let's just speak very briefly about this umbrella policy. New York State is the most profitable state in the United States for insurance companies. We have very, very favorable legislation for the insurance companies. And the implied threat, whenever the insurance company asks in the long-term care arena, they ask the Department of Financial Services for a rate increase. And do you know how many times they've been rejected? 0, because the implied threat is if you don't give us the thing we want, we're going to move all of these jobs to New Jersey. So the insurance company gets whatever they want. And I can have a $1 million umbrella policy, and they have geniuses on the other side who are finding a way for me not to be able to collect. So if the trip and fall in my home was through a lady that I was paying off the books to care for my mother, and she cuts her hand making a sandwich, is there any coverage when she sues me? No, she's going to own my house because that is an illegal employment situation. The same as if I was running a brothel, there's going to be no payment on it. So yes, we should all sleep soundly at night having insurance in place, but it's not the be all and end all. We want to have a belt and suspenders, insurance plus some asset protection. Yes.
1031 exchanges. You avoid paying for depreciation.
Yeah, you defer.
When you die, you give it to your kids, they don't pay depreciation.
That's right.
If you want to give one pound to your kids now, who pays depreciation?
Yeah, don't give a condo to the kids now because they're going to be paying capital gains. I would not do that. I would give it to them through the trust. Yeah. They could live there now. Okay, well, that's a specific question. You can do a 1031 exchange on assets that are in this trust. If you sell your home from within the trust, you continue to qualify for your 250 and 250 if you have a spouse capital gains exclusion. Yes. How can you avoid probate if you own a co-op? So about 1/2 of the co-ops in this area allow trust ownership and the others do not. For asset protection purposes, we can do something called a limited assignment, whereby you transfer the economic interest pertinent to the shares of stock into this trust. But your name remains on the books of the co-op. But then at death, the probate, yeah, you'd still have to go to probate, but our argument to the surrogates court is because you stripped out the value, that it qualifies as a small estate proceeding, which is a DIY job with a $1 filing fee. Before we take a few remaining questions, I do want to pivot and talk about the importance of pre-planning the funeral. One of the peculiarities about my profession is that I deal with grief-stricken people on sometimes a daily basis, definitely a weekly basis. And when the adult children tell me that their parents did pre-arrangements. They feel like this was a gift and a blessing, and it's like our last parental act, right? I want to save my sons from, I think we've all been there, and I've been in a room sobbing hysterically with this man, and we lose our minds a little bit when we're grief stricken and we're not making good decisions, and it's a special form of torture, I think, making these nitty-gritty decisions. And if I have folks who tell me my parents did this for me, so I wouldn't have to go through this, it's like they feel like they're floating a little bit. I can't tell you how happy and proud they are that they have parents who are sensitive and loving enough to do this. And I think you would say, John, that you don't have to get into all of the nitty gritty, you know, if that creeps you out a little bit, it can be as general as you want. And I can't speak highly enough about Gleason's. It's been in business for over 100 years. And I've told John before that going through the safe in my home, my great grandfather in 1927 was Martin. It wasn't you, you weren't here then. Martin Gleason is on the death certificate. So I definitely feel a very strong bond with John Golden and the entire Gleason's team. They're really, really special and wonderful people. And I know many of you, you know, had your parents at, you know, Quinn Fogarty, and we feel like we want to go where our parents went, but it's not the same because they sold out to venture capitalists. This is the only family-owned funeral establishment in this area. Now, one of the big question is, can I do these legal documents on my own? Can I get this kit off the internet? And I would say, like so many things in life, it's not all one or the other, right? There's a mix. There are things you can and should do on your own. A healthcare proxy. I was a co-sponsor of that legislation in the 90s. That is designed to be a DIY project. So if an attorney is charging to do a healthcare proxy, that's bananas. It shouldn't be. Go onto my website, myelderlawadttorney.com, and print the healthcare proxy. I said before, you don't need a lawyer to do a living will. The living will, you put your wishes in there. It can be as specific as you want. If I'm concerned that I might have dementia one day and lose my ability to communicate, but I think, well, maybe I'll still like the way pizza tastes, I'll put my, you know, favorite foods in this living will. You know, it can't hurt. The other document you can and should do on your own is the appointment of agent to make funeral decisions. And it's a very gruesome sounding title that they give that document. The technical title is appointment of agent to dispose of remains. It sounds like a highway sanitation crew, but yeah, those things you can do on your own. And I think if you were to start there, go onto the website, download those forms, fill out those forms, you're going to feel a little better, a little more virtuous. You took the first step to wrestle all of this under control. Yes.
Can you just go over the website again?
I'm sorry. It's and those of you who have the red folder, the website is on the card. It's myelderlawadttorney.com. Now, one of the reasons why we do all of this is to have a more valuable estate for our benefit and the benefit of our beneficiaries down the road. What does it matter how diligently I've saved, how well I've invested, if I have a 40% chance of losing assets to a long-term illness? If I have a chance of losing assets to capital gains taxes because I did, you know, boneheaded planning, or a financially devastating breakup, either mine or a child's, and I have to give her tens of thousands for some divorce attorney because we didn't have the assets protected. So we want to go out of our way to do some planning to protect the value of our assets. And for many of us, the single biggest asset we have is our primary residence. So now I'm going to put the Legaz team on the spot. We have David and Nancy Legaz in the back, my partners in real estate. If I have someone who needs a broker or needs an appraiser, they're definitely my go-to. Dave's a retired. I don't know what you might be reformed from, but you're a retired police officer, and I trust them implicitly. So I guess the question for you guys is, I am an HGTV addict, and I'm smart enough to know that I shouldn't be doing all of this stuff because I have zero talent. But what would you say, Dave, is the number one thing that people should not try to tackle on their own because it would just end in a disaster and you wouldn't get dollar for dollar return upon sale?
Yes, that's a great question, and good afternoon. We're Whitestone residents, we're senior real estate specialists, so we're trained to take schooling to help.
Thank you. We had taken extra schooling to help seniors in the transition of housing and help the family members who help the seniors. So the biggest question is, what do I do for my home? And we watch HGTV all the time and they're saying do all these grand renovations. But in reality, you want to deep declutter, you want to do a good cleaning, possibly paint and remove any worn carpeting to expose the floor. And anything that you venture in, just know what the dollar return is going to be on that. A lot of times it doesn't make sense. A buyer may want to do their own renovations, but consult a realtor and make sure they are trained to assist in that aspect.
Thank you.
Thank you.
Thank you. Okay, any final questions? Yes, Marilyn.
First of all, thank you for offering this.
Thank you.
For the yellow sunshine today. Here's the question. I'm just wondering, in two different situations, what the basis would be. If the person that has the trust dies, and so the property comes out of the trust to go to the beneficiaries, is their basis the value of the property upon the day of death?
You get the so-called step up in basis, meaning that when the property comes out of the trust upon my death to the beneficiaries, their cost basis is equal to the then higher fair market value. So if they turn around and sell it, they'd have zero capital gains.
And secondarily, if the house has to be sold while it's still in the trust, what is the basis?
Okay, so this trust for income tax purposes is under the Internal Revenue Code a disregarded entity. It doesn't help us, it doesn't hurt us. If it's my primary residence, I'll get the $250 forgiven. I want to leave you with one kernel of thought on the estate taxes. Now, many people would like to make charitable contributions within their estate planning, but they say, well, you know, my kids need the money, so I'm not going to do it. But what if you did a pivot clause that said, I want to leave money, let's say to St. Luke Church, monies that would otherwise be payable in state or federal estate taxes. So you're not taking anything away from your kids. You're simply saying, if there was $1 that would be payable in taxes, instead I'm going to give it to this parish community for its ongoing programs and support. So that's an example of thinking a little bit creatively. Yes.
That property is spoken on your trust, and I see your trust.
So you're asking about suing me if you trip on my property, so I'm very nervous. I have a lovely, lovely guy who reminds me of my younger brother, and he cleans the gutters And on 2 separate occasions, he's called my cell phone asking me for advice about suing a homeowner because he tripped on the roof. And I think, oh my God, I love this guy, but he can never go up on my roof again. So if I see you at my office, I'm gonna walk you over the threshold. So if you were to trip in property owned by a trust and you come after me, you would probably be paid by the insurance carrier. I mean, you're still going to have a lawsuit. And it's very important that we let the insurance company know that we changed the deed into this hybrid trust. And you would be paid for any injuries through the insurance carrier, but you wouldn't be able to get at me personally. Well, the trust is not an asset. So you hurt yourself on the property, you're going to sue the owner of that property. It's much more difficult to break through a trust, but you can get a payout from the insurance. Okay, maybe 2 more. Yes.
What do you mean the power of attorney?
I'm sorry?
The power of attorney. You had a trustee.
Yeah, so if the trust owns your real estate, and I'm telling you, leave your bank accounts in your own name, then you definitely need power of attorney, because the plan is if we get sick, we want the agent under the power of attorney to go to the bank and throw the CDs in the trust at that point in time. So they can only break a CD early, or they can only transfer title to an account if there is a power of attorney. Yes.
What's the third type of asset?
Oh, okay. Type number 1, retirement accounts, invisible. Real estate should be in the trust. It'll be invisible in 5 years. Your everything else, keep it in your own name, enjoy yourselves. But if we get sick, we're either going to move it to the well spouse, or if we're a single person, we're going to move it into the trust. Yes. Okay, 1 more in the red. What's the best way to leave a house to 4 beneficiaries? I'll let the rest of the room answer. A trust. Okay, with that, it's been a pleasure. Thank you. That I will answer them if they give me an email.
Sounds good. I was just sharing your website.
So on the website, they can email. Hey.
And I had more than one. And I have a.
Sounds good. Okay. Calling off.
And they said they called me on Monday.
They called you back. Once we had some questions.
And I called you back and they said.
No, not in the market. Never been in. Call the
Yeah,